This is a summary of Part 1 of the Data Protection Act of 2019 of Kenya. Part 1 of this act focuses on preliminary matters, establishing the Act's purpose, defining key terms, and outlining its scope of application. Here's a breakdown. Section 1, short title. This section simply states the name of the Act, the Data Protection Act, 2019. Section 2, interpretation. This section defines crucial terms used throughout the Act to ensure clarity and consistent understanding. Some key terms defined include anonymization, the irreversible removal of personal identifiers, making it impossible to identify the data subject. Biometric data, data derived from processing physical, physiological, or behavioral characteristics like fingerprints or DNA. Consent, clear, affirmative action signifying agreement to data processing. The consent must be freely given, specific, informed, and unambiguous. Data controller, the entity that determines the purpose and methods of processing personal data. Data processor, the entity that processes personal data on behalf of the data controller. Data subject, the individual to whom the personal data relates. Personal data, any information relating to an identified or identifiable natural person. Processing, any operation performed on personal data, including collection, storage, use, disclosure, and deletion. Sensitive personal data, data revealing sensitive aspects of a person, such as race, health status, religious beliefs, sexual orientation, etc. Section 3, Object and Purpose of this Act. This section outlines the Act's aims, which are to regulate how personal data is processed. Ensure data processing aligns with the principles outlined in Section 25, discussed later. Protect individual privacy. Establish legal and institutional frameworks for personal data protection. Empower data subjects with rights and remedies to protect their data. Section 4, Application. This section defines the Act's jurisdiction. It applies to personal data processing within a record, whether by automated or non-automated means, as long as it's part of a filing system. By data controllers or processors established or residing in Kenya while operating within the country. By data controllers or processors not established in Kenya but who are processing the personal data of Kenyan residents. In essence, Part 1 lays the groundwork for the Data Protection Act by clarifying its objectives, defining essential terminology, and specifying the individuals and organizations subject to its provisions. This is a summary of Part 2 of the Data Protection Act of 2019 of Kenya. Part 2 of the Act centers around the establishment and operation of the Office of the Data Protection Commissioner, a crucial entity responsible for enforcing the Act's provisions. Here's a breakdown of this section. Establishment and structure of the office, sections 5 to 6. Section 5 establishes the Office of the Data Protection Commissioner as a body corporate with perpetual succession, meaning it's a separate legal entity that continues to exist even if its members change. This allows the office to own property, enter contracts, and sue or be sued. The Data Commissioner heads the office as its accounting officer and oversees a staff appointed through consultations with the Public Service Commission. Section 6 outlines the appointment process for the Data Commissioner. This involves a rigorous procedure overseen by the Public Service Commission, culminating in the President's nomination of a candidate from a shortlist of 3, and subsequent approval by the National Assembly. Qualifications, functions, and powers of the office, sections 7 to 10. Section 7 details the qualifications for the Data Commissioner, emphasizing a strong academic background, significant experience, at least 10 years, in relevant fields, and adherence to Chapter 6 of the Constitution, on leadership and integrity. The Commissioner is appointed for a single, non-renewable term of 6 years. Section 8 outlines the functions of the office, highlighting its role in overseeing and enforcing the Act, maintaining a register of data controllers and processors, promoting data protection awareness, conducting investigations, and fostering international cooperation on data protection matters. Section 9 grants the Data Commissioner specific powers to effectively execute their duties, including conducting investigations, summoning witnesses, obtaining professional advice, facilitating dispute resolution, and imposing administrative fines for violations. Section 10 allows the Data Commissioner to delegate any powers granted under the Act to other regulators established by Parliament, subject to specific conditions. Vacancy and removal of the Data Commissioner, Sections 11 to 12. Section 11 describes the circumstances leading to a vacancy in the office of the Data Commissioner, such as death, resignation, conviction of a serious offense, or removal from office due to specific grounds. Section 12 details the process for removing the Data Commissioner from office. This procedure is initiated through a complaint to the Public Service Commission, which investigates the allegations and recommends a course of action to the Cabinet Secretary. The Data Commissioner is afforded due process, including written notification of the reasons for their potential removal and an opportunity to present a defense. Staffing, remuneration, and protection, Sections 13 to 17. Sections 13 and 14 address the appointment and remuneration of the office's staff, emphasizing collaboration with the Public Service Commission in determining staffing needs and aligning compensation with the Salaries and Remuneration Commission's recommendations. Sections 15, 16, and 17 highlight the importance of confidentiality and protection from personal liability for the Data Commissioner and the office's staff, as long as they act in good faith and within the confines of the Act. This ensures that the office can operate independently and effectively without fear of undue influence or reprisal. In summary, Part 2 of the Data Protection Act establishes the Office of the Data Protection Commissioner as a powerful and independent entity. By outlining its structure, functions, and powers, the Act underscores its commitment to robust personal data protection in Kenya. This is a summary of Part 3 of the Data Protection Act of 2019 of Kenya. Part 3 of the Data Protection Act of 2019 focuses on the registration requirements for data controllers and data processors. It outlines who needs to register, the application process, and the implications of registration. Registration requirement and thresholds, Sections 18 to 19. Section 18 mandates that data controllers and data processors must register with the Data Commissioner unless they fall below certain thresholds. This requirement aims to ensure that entities handling significant amounts of personal data are accountable to the Office of the Data Protection Commissioner. Section 19 details the registration application process. Data controllers and processors must provide specific information, including types of personal data processed. This helps the Data Commissioner understand the nature and sensitivity of the data being handled. Purpose of data processing. This ensures that data processing activities have a legitimate basis and are not excessive in relation to their stated aims. Categories of data subjects. This clarifies who the individuals are whose data is being processed. Risk mitigation measures. Applicants must describe their safeguards and mechanisms to protect personal data, demonstrating their commitment to data security and minimizing potential risks to data subjects. It's important to note that providing false or misleading information during the registration process is considered an offense under the Act. Registration certificate, register, and audit, Sections 20 to 23. Section 20 states that the registration certificate's validity period is determined on a case-by-case basis, considering the nature and duration of data processing activities. It can be renewed upon expiry. Section 21 establishes a public register of registered data controllers and processors, ensuring transparency, and allowing individuals to verify if an entity handling their data is compliant with the Act. This reinforces accountability and public trust. Section 23 empowers the Data Commissioner to conduct periodic audits of data controllers and processors, ensuring ongoing compliance with the Act's provisions. This proactive approach helps identify and address potential data protection issues before they escalate. Data Protection Officer, Section 24. Section 24 introduces the role of the Data Protection Officer, DPO, an expert who advises and supports data controllers and processors in complying with the Act. While not mandatory for all organizations, the Act specifies situations where a DPO is required, such as when processing is carried out by public bodies or private entities, excluding courts. The core activities involve regular and systematic monitoring of data subjects. Sensitive personal data is being processed. This section also outlines the qualifications, responsibilities, and publication requirements of the DPO's contact information. In essence, Part 3 operationalizes the Act by setting out the framework for registration, promoting transparency through a public register, and introducing the role of the DPO to guide and support compliance efforts. This section emphasizes accountability and proactive measures to protect personal data. This is a summary of Part 4 of the Data Protection Act of 2019 of Kenya. Part 4 of the Kenyan Data Protection Act gets to the heart of the matter, outlining the principles and obligations surrounding personal data protection. It emphasizes the rights of individuals, data subjects, and the responsibilities of entities handling personal information, data controllers and processors. Guiding Principles, Section 25. This section establishes 8 fundamental principles of data protection, which are strikingly similar to the General Data Protection Regulation, GDPR, of the European Union. These principles state that personal data must be processed respecting privacy, underscoring that individuals have a fundamental right to privacy regarding their personal information. Processed lawfully, fairly, and transparently, meaning data processing should have a legitimate basis, be conducted ethically, and be clear and understandable to the data subject. Collected for specific purposes and not repurposed incompatibly, this limits the use of personal data to the purposes for which it was originally collected and prevents mission creep without proper justification and consent. Adequate, relevant, and limited data collection should be limited to what is necessary and directly relevant to the stated purposes, preventing excessive or unnecessary data collection. Collected with a valid explanation for family/private matters, recognizing the sensitive nature of such information, this provision mandates that a clear justification be provided when collecting data related to an individual's family or private life. Accurate and up-to-date data controllers and processors are responsible for maintaining data accuracy and taking prompt steps to rectify or erase inaccurate information. Stored for limited durations, data should not be kept longer than necessary, and appropriate time limits should be established for data retention. Not transferred outside Kenya without safeguards, emphasizing the importance of data protection even when data crosses borders. This principle mandates that adequate safeguards be in place to ensure the security and protection of data transferred internationally. Data Subject Rights, Sections 26 to 27. The Act explicitly recognizes several key rights of data subjects, empowering individuals to exercise control over their personal information. Right to be informed. Data subjects have the right to know how their personal data will be used. This includes understanding the purpose of data collection, potential recipients of the data, and the safeguards in place to protect their information. Right of access. Individuals have the right to access their personal data held by data controllers and processors. This allows them to verify the accuracy of their data and understand how it is being used. Right to object. Data subjects can object to the processing of their personal data if they believe it infringes upon their rights or freedoms. Right to correction. They have the right to have inaccurate or misleading data corrected promptly. Right to deletion. Erasure. Data subjects can request the deletion of their data under certain circumstances, such as when the data is no longer necessary for the original purpose or was processed unlawfully. Section 27 further clarifies that these rights can be exercised by parents or guardians on behalf of minors or individuals with disabilities. Data collection and notification. Sections 28 to 29. The Act sets out specific requirements for data collection, emphasizing fairness and transparency. Direct collection. Data controllers and processors are generally required to collect personal data directly from the data subject, fostering accountability and ensuring data accuracy. Indirect collection. The Act does allow for indirect data collection in limited circumstances, such as when the data is publicly available, the data subject has provided consent, or when necessary for legal or public interest purposes. Lawful and specific purpose. Data controllers and processors are prohibited from collecting, storing, or using personal data for any purpose other than what is lawful, specific, and explicitly defined. This prevents function creep and ensures that data processing remains within the bounds of what is permissible. Duty to notify. Before collecting personal data, data controllers and processors have a duty to inform the data subject about their rights, the purpose of data collection, data recipients, security measures, and the consequences of not providing the requested data. Lawful processing and impact assessments. Sections 30 to 31. The Act provides a framework for ensuring that data processing is conducted lawfully. Grounds for lawful processing. Section 30 outlines the conditions under which data processing is considered lawful. This includes obtaining explicit consent from the data subject, fulfilling contractual obligations, complying with legal requirements, protecting vital interests, or carrying out tasks in the public interest. Data Protection Impact Assessments. DPIAs. Section 31 mandates DPIAs for processing activities that are likely to pose high risks to the rights and freedoms of data subjects. These assessments analyze the necessity and proportionality of the processing, assess potential risks, and outline mitigation measures. The Data Commissioner may be consulted if a DPIA reveals a high risk to data subjects. Consent, children's data, and restrictions. Sections 32 to 34. Conditions for valid consent. Section 32 details the requirements for valid consent, emphasizing that the data controller or processor bears the burden of proof. Consent must be freely given, specific, informed, and unambiguous. Children's data, recognizing the vulnerabilities of children online. Section 33 establishes stricter rules for processing children's data. Parental or guardian consent is generally required, and data processing must be conducted in a way that protects and advances the child's rights and best interests. Restrictions on processing. Section 34 empowers data subjects to request restrictions on the processing of their data under certain circumstances, such as when the accuracy of the data is contested or when processing is deemed unlawful. Automated decision-making, commercial use, and data portability. Sections 35 to 38. Automated decision-making. Section 35 addresses the increasing use of automated systems in decision-making processes. Data subjects have the right not to be subject to decisions based solely on automated processing that produce legal effects or significantly impact them. Exceptions are made for contractual necessities, legal authorizations, or explicit consent. Commercial use of data. Section 37 regulates the commercial use of personal data, requiring explicit consent from the data subject or authorization by law. Anonymization is encouraged to minimize privacy risks when using data for commercial purposes. Right to data portability. Section 38 grants data subjects the right to receive their personal data in a structured, commonly used, and machine-readable format. This allows them to transfer their data to another data controller or processor without hindrance. Data retention, rectification, and security, sections 39 to 43. Limitations on data retention, Section 39 mandates that personal data be retained only for as long as necessary for the original purpose or as required by law. Data controllers and processors must establish appropriate retention periods and securely dispose of data that is no longer needed. Right of rectification and erasure, reiterating the principles of data accuracy, Section 40 allows data subjects to request the rectification of inaccurate data and the erasure of data that is no longer necessary, irrelevant, excessive, or unlawfully obtained. Data protection by design and default, Section 41 emphasizes the importance of incorporating data protection measures from the outset of any system or process that handles personal information. This includes implementing appropriate technical and organizational measures to ensure data security and minimize risks to data subjects. Data breach notification, Section 43 outlines the procedures for reporting data breaches to the Data Commissioner and affected data subjects. Data controllers must notify the Data Commissioner of a breach without undue delay, within 72 hours, then communicate the breach to data subjects within a reasonable time frame, providing sufficient information for them to take protective measures. Key takeaways. Part 4 of the Kenyan Data Protection Act establishes a comprehensive framework for protecting personal data. It places strong emphasis on individual rights, outlining a range of mechanisms for data subjects to control their information. At the same time, it imposes significant obligations on data controllers and processors, requiring them to handle personal data responsibly, transparently, and securely. This is a summary of Part 5, Handling Sensitive Personal Data in Kenya. Part 5 of the Kenyan Data Protection Act focuses specifically on sensitive personal data, recognizing that this type of information requires heightened protection due to its potential for misuse and the potential harm to individuals if compromised. What is sensitive personal data? Section 15 and 44. While the Act provides a general definition of personal data as any information relating to an identified or identifiable natural person, it carves out a special category of sensitive personal data, which includes race, health status, ethnic social origin, conscience, belief, genetic data, biometric data, property details, marital status, family details, including names of children, parents, and spouses, sex, sexual orientation. The Act makes it clear that no category of sensitive personal data shall be processed unless the general data protection principles outlined in Section 25 apply. This means that even when handling sensitive information, data controllers and processors must still adhere to the core principles of lawful processing, purpose limitation, data minimization, accuracy, storage limitations, integrity and confidentiality, and accountability. Permitted grounds for processing sensitive data, Section 45. Given the heightened sensitivity of this data, the Act lays out specific and limited grounds for processing, which are more restrictive than those for general personal data. Not-for-profit organizations, with safeguards processing by foundations, associations, or other not-for-profit organizations is permitted if the processing relates solely to their members or individuals with regular contact for the organization's purposes. The data is not disclosed outside the organization without the data subject's consent. Publicly available data processing is allowed if the data subject has manifestly made the sensitive personal data public. Legal claims processing is necessary for establishing, exercising, or defending legal claims. Contractual obligations. Processing is necessary for carrying out obligations or exercising specific rights of the data controller or the data subject. Protecting vital interests. Incapacity processing is permitted to protect the vital interests of the data subject or another person when the data subject is physically or legally incapable of giving consent. Special case, personal data relating to health, Section 46. Recognizing the extreme sensitivity of health information, the Act imposes even stricter conditions for processing this type of data. Processed by healthcare providers or under confidentiality obligations, personal data relating to health can only be processed by a healthcare provider or a person subject to professional secrecy obligations under any law. Public health and confidentiality. The processing is also permissible if it's necessary for public health reasons or carried out by someone legally bound by confidentiality. Additional categories and safeguards, Section 47. The Act grants the Data Commissioner the authority to designate additional sensitive data categories. The Data Commissioner can prescribe further categories of personal data as sensitive based on the potential risk of harm to data subjects, confidentiality expectations, and the adequacy of existing protections. Specify further grounds for processing. For any additional categories, the Data Commissioner can outline specific and appropriate grounds for processing, considering the potential risks involved. Require additional safeguards. The Data Commissioner can also specify additional safeguards or restrictions for processing certain categories of personal data to mitigate potential risks. Key points. Part 5 significantly strengthens the protection of sensitive personal data in Kenya. It emphasizes the need for explicit consent and robust safeguards. The Act provides flexibility for evolving data protection needs by empowering the Data Commissioner to adapt regulations over time. This is a summary of Part 6, Transferring Personal Data Outside Kenya. Part 6 of the Kenyan Data Protection Act addresses the cross-border transfer of personal data, establishing rules and safeguards to ensure the continued protection of this information when it leaves Kenya. This is particularly important in today's digital age, where data can flow seamlessly across borders. Conditions for transferring data out of Kenya, Section 48. The Act recognizes the need for data to move freely but places strict conditions on such transfers to ensure data protection remains paramount. Data controllers and processors can only transfer personal data outside Kenya if they meet one of the following conditions. Proof of adequate safeguards. General data. The data controller or processor must demonstrate to the Data Commissioner that appropriate safeguards are in place in the recipient country to ensure the security and protection of the personal data. Proof of adequate safeguards. Similar laws similar to the above, but the data controller or processor must specifically demonstrate that the recipient jurisdiction has data protection laws comparable to Kenya's. This provides an added layer of assurance that the data will be handled responsibly. Necessity for contractual obligations. The transfer is deemed necessary for fulfilling contractual obligations, including performing a contract between the data subject and the data controller or processor, implementing pre-contractual measures at the data subject's request, concluding or performing a contract in the data subject's interest between the data controller and another party. Public interest. The transfer is considered necessary for a matter of public interest. Legal claims. The transfer is essential for establishing, exercising, or defending legal claims. Protecting vital interests. The transfer is required to protect the vital interests of the data subject or others when the data subject cannot provide consent due to physical or legal incapacity. Compelling legitimate interests. The data controller or processor has compelling legitimate interests for the transfer, and these interests are not overridden by the data subject's rights and freedoms. Additional safeguards for sensitive personal data, Section 49. Given the heightened risks associated with sensitive personal data, the Act imposes even stricter requirements for transferring this type of data outside Kenya. Explicit consent required. Transferring sensitive personal data requires not only meeting one of the conditions outlined in Section 48 but also obtaining the data subject's explicit consent. This underscores the importance of informed consent when dealing with such data. Confirmation of safeguards. Along with consent, the data controller or processor must obtain confirmation that the recipient country has appropriate safeguards in place to protect the sensitive data. Data Commissioner's oversight. The Data Commissioner has the authority to request evidence of the safeguards' effectiveness or the legitimacy of compelling interests. Potential for prohibition or suspension. To protect data subjects' rights and freedoms, the Data Commissioner can prohibit, suspend, or impose conditions on the transfer of sensitive personal data. Data Localization Requirement, Section 50. The Act also introduces a data localization provision, granting the Cabinet Secretary the power to mandate that specific types of data processing occur only within Kenya. This power is subject to strategic national interests or revenue protection justifications. Key takeaways. Protecting data beyond borders. Part 6 highlights Kenya's commitment to safeguarding personal data even when it is transferred internationally. Stringent requirements, especially for sensitive data. The Act sets a high bar for cross-border data transfers, particularly for sensitive personal data, reflecting its sensitivity. Data Commissioner plays a key role. The Data Commissioner plays a critical role in overseeing and enforcing these provisions, ensuring data transfers meet the required standards. Data localization considerations. The Act's data localization provision allows for limitations on cross-border data flows based on national interests, highlighting the potential intersection of data protection and broader policy objectives.